when you join, please mute yourself and also turn your screen off because it will be a recording program.
Okay. Thank you. My name's Ken Vercammen. I'm an attorney in faraway Edison, New Jersey. My office was in Metuchen for a decade. I'm a local guy, having went to St. Francis Grammar School, was married in Metuchen, so I've been around for a lot of years. So I'm here to try to educate people for a little while on wills, estates, probate, powers of attorney, things like that. But also the idea is to try to, explain to people what happens when you don't have any kind of planning.
I can't hear anything.
So if you don't have planning, then it becomes a problem. Now, oftentimes people would ask me. I'd see people like at social events, Chamber of Commerce, or and they would say, Kenny, why do I really need to have a will? Doesn't everything go to my spouse if I pass away? I goes, well, the answer is yes, but that's not doing planning. If you don't have proper planning, you're really going to make it cost more money for your family and making everything more stressful. And the whole idea of doing planning is to try to make things as easy as possible for everyone. So for example, if you pass away, you leave no will, or your will is not valid because it wasn't signed correctly. Number one, the procedure to distribute assets becomes much more complicated. It will require, let's say there's kids, it will require all the children to select someone to be the administrator, then all the children have to sign a renunciation affidavit in front of a notary, and then you have to pay fees to have that renunciation signed. And if all the children don't sign a renunciation affidavit, then a complaint order show cause has to be filed in the Superior Court, costing over $3,000, spending time in court for having the judge then pick someone who would be the administrator. Well, certainly spending $400 or so on having a will is less expensive. Number two, if there's no will, there's additional expenses that have to be incurred because there's higher administration fees, and then there's also a thing that has to be taken out called a surety bond. With a bonding company, and the fee has to be paid every year as long as the estate's open. Number three, state law determines who gets assets, and sometimes it's people that don't care about you. And we're going to go into later on, while there's no rule that requires that everyone be treated equally, or you get to decide who you want. People that have minor children, well, if there's no will and there's a sudden, people are suddenly die, a stranger determines who gets custody of children, and that stranger is a Superior Court judge. Again, going in front of judges costs a lot of money. You lose the opportunity to possibly reduce taxes. If there's no spouse, no close blood relatives, the state gets someone's money. But most importantly, when people don't have wills or any kind of planning, it usually causes aggravation, fights, sometimes lawsuits amongst the family. So when people are grieving and dealing with death, they shouldn't be overwhelmed with financial concerns and estate problems. As when there's not a will, or the will wasn't properly signed because someone tried to do some cheap things online. So think about, who would you like to get your assets? Who don't you want to get your assets? When there's minor children, minor grandchildren, who would be the best choice to hold their money? Who would not be the best choice? So also, I'll keep on saying, beware of these online documents that are do-it-yourself things, because we find people don't do it right, or they're done hastily, and judges often throw them out. So I wouldn't recommend an online form, just like I wouldn't recommend anyone trying to do their own electrical work. People that try to watch a YouTube video and do their own plumbing work typically will do it wrong. So have a professional do it right, and make sure that you have a self-proving will. Now, surprisingly, one of the things that we changed last year was to try to make things easier for everyone. And back last January, we switched from having people handwrite what they want in a will questionnaire to people typing up everything on a very short, 2-page will questionnaire. So when COVID hit last March, we were still able to do people's documents without people having to come into our office. And everyone found that was an easier way to do stuff. Otherwise, people without work had to take a day off of work, maybe bring their spouse in. They would sit down in the office and we go over things. And, and then they had to make an appointment to come back and sign. Well, we tried to make it easier for people, and that's what most attorneys have done, where we email in a short questionnaire. The questionnaire says, okay, who's executor 1, who's executor 2. People type up things, because who really doesn't have a computer or an iPhone nowadays? If you don't have a computer and iPhone, then you probably don't have that many assets. And someone said, well, do these older people have computers? And I was surprised when I went to talk to senior groups. Yeah, many of them do have the computers and laptops, because they found that they could communicate with their grandkids and share photos, etc. So logistically, people type in for the attorney. They type in their names. So that's great, because now I don't have to worry about people's handwriting or misspelling names. And then they type in who's going to be executor 1, who's going to be executor 2. And you never want to have joint executors. There's a reason why there's only one president of the United States and then a vice president. So you have an executor 1 and executor 2. Even if they're twins that live together, having joint executors creates twice as much work. And, part of doing this planning is to try to make it as easy as possible. And that's where people cooperate. Sometimes you get, kids that, don't cooperate. Let's see. So, there's one steering wheel, there's one captain of ship. You have an executor 1 and executor 2. And when people says, oh, I'd like to have, both, they goes, listen, take my advice. This is what I do for a living. I know you love both your kids. You don't want to pick one over the other. But the whole idea is making it easier, because if there's joint executors, that means 2 people got to sign every check. First of all, 2 people have to qualify before the county surrogate. 2 people then got to open up a bank account. 2 people got to sign the cards at the bank. 2 people got to sign every check. 2 people have to sign the listing with the realtor. 2 people got to sign the contract for sale. 2 people got to sign addendums. 2 people got to go to the closing. 2 people have to go do everything. So again, it's best to have an executor 1 and executor 2. We used to ask many questions of what assets people have. Well, believe it or not, New Jersey has reduced what the taxes are. Okay? And what we want to do is have we want to try to go over what's the New Jersey estate tax now. Well, they did away with it 2 years ago. It used to be $675,000. Everything was taxed over that at a high rate. Now New Jersey did away with the New Jersey estate tax. Now there is a federal estate tax, but that's for estates over $11,700,000. And Ms. Chung and I know in Metuchen, there's so many people that we know that have $11.7 million everywhere. But most people don't need this kind of sophisticated estate planning. But we do ask, okay, do you have real estate? What's the ballpark amount of what the assets that you have? Let's see, do you have real estate in any other state? Because if there's real estate in another state, that has to be, there's a procedure called ancillary probate. Now, in addition, you certain assets that don't pass under the will. They pass by title. And an example of that is when a house is owned husband and wife. Well, if a house is owned husband and wife, it's what's called tenants by the entirety, and it goes, it's owned by both of them, but it's not owned 50-50. It automatically goes to the survivor. All right, bank accounts that are payable upon death, POD, joint tenancy, a CD payable, that automatically goes to the survivor. A will cannot change that. certain
going way
assets
too
passed
fast.
by contract.
He's going way too
Those
fast.
are
Yeah, that's fine.
those
Listen,
are
don't take notes. Just
those
listen.
are assets. Let's see, and so what are assets that pass by contract? IRA, 401k, life insurance, annuity, anything that has a beneficiary. So I tell people that it's a good idea to get